appeal in the matter of Frangou and Frangos.
Good morning, gentlemen.
My lady.
Good morning,
and my lord.
Mr. Hill. You can assume to start with that we have read widely, and thank you very much for your timetable, with which we are content say that it assumes we will sit till 4:30 today and tomorrow, which we will not. We will sit until 4:15, so perhaps you'd adjust accordingly. And just to give you an indicator, which is hardly surprising, but two things that we're particularly interested in are, first of all, obviously, the time limit, if there is a time limit, in relation to Clause 5. And I use that term because it's intended to be entirely neutral, and therefore, inevitably, something that you're going to concentrate on, the construction of Clause 5. And then the effect, and I think it's in 2017, of the change in the ownership of Brandon, the effect which that may have on the agreement as a whole. But neither of those things will come as a great surprise to you. But we'd be grateful if you'd concentrate on those. Thank you very much.
I'm grateful, my lady. But I represent my lady, the appellant in this matter, Miss Frangou, with Mr. Fell behind me, Mr. Caplin and Mr. Dunwalsh represent the respondent. Like we did below, it's no disrespect to the parties, but we'll refer to them as AF or JF or Angeliki or John. We found at the trial below that was the most helpful way of doing it. The other thing I'd just like to say at the outset is John Frangos is in court. Angeliki Frangou apologises. She can't be in court, but she's following online. She has an important business matter in Greece as part of her company filings, and she has to follow online. My lady, my lords, you'll appreciate this. Our appeal itself concerns a reasonably short issue of construction of a payment obligation in a bespoke contract between a sister and a brother. And as you know, and I'll take you to it in a moment, that contract can be found in tab 8 of the core bundle. However, the respondent's notice raises two cases involving the doctrine of implied rescission and 3 different quantum cases. All of those 5 issues in the respondent's notice require a consideration of the facts, many of which are hotly disputed. So that's the outline, because of course our appeal, we say, doesn't involve any facts at all. What I intend to do, with the court's permission, is obviously deal with the appeal notice first. I am going to spend, I suspect, most of today on the appeal notice. As for the respondent's notice, I'm going to deal with that pretty briefly in terms of the implied rescission cases, because we've gone second in our skeleton arguments, and we've set out quite fully in our skeleton arguments what we say about those. And I'll probably save my powder for reply if I need to add anything. However, Mr. Fell behind me will be dealing with today the 3 quantum cases from the respondent's notice, because they do need a little more explanation. Now, the structure of my submissions on the main appeal are going to be, firstly, I'm going to deal with JF's arguments surrounding the test on appeal in cases of contractual interpretation, and he runs the discretionary test. Secondly, there are 3 main themes flowing throughout my learned friend's skeleton argument, and I'm going to deal with each of those 3 themes separately before I deal with the construction issues. Because if you deal with each of those 3 themes separately in advance, it becomes much quicker when you get to the construction arguments, and in particular looking at my learned friend's justifications. When I do those 3 themes, I'm going to just briefly take you through the TT agreement, Taurus 2 agreement in detail. Then I'll turn to the first ground of appeal, which my lady has rightly highlighted is the time limit, which is the judge below is called the duration issue, and then I'll turn to the durability issue, which is the ownership issue. I suspect I'm going to take a little bit of time before I get to the meat of dealing with those 2 construction cases, because we say there's a number of matters beforehand that it's important that I take the court through, and in particular the three themes. So I do ask for your patience. I will get there, and I'll do it in some detail, but there is quite a lot I would like you to hear beforehand. Can I very briefly now start, firstly, with the law as to factual matrix and the construction of the contract, and it's not an exercise of discretion. The appeal, as we say, involves a pure issue of construction. JF makes a submission in his skeleton argument at paragraphs 7 and 58 that a construction of a contract against a factual matrix is or involves the exercise of a discretion. He therefore says the test to be applied on AF's appeal is that of an appeal against an exercise of discretion, and he relies on G&G and the Tanner and Cameron case. I'm sure I don't need to take too much time on this, but very briefly, if I can just ask you to look at the authorities bundle, and I'll take you straight to a passage in Lewison, which you'll see in tab 18 at the back of the bundle.
18?
18, my lady, and it's picking it up at bottom of page 372 of the bundle. Section 4, although a contract may potentially have more than one possible meaning, the court can select only one meaning. In making its selection, the court applies the same principles, whatever the subject matter of the contract. The meaning of the contract, once interpreted, does not change. And then the author cites Lord Justice Diplock in the Slim and Daily Telegraph case. Everyone outside a court of law recognises words are imprecise instruments for communicating the thoughts of one man to another. The same words may be understood by one man in a different meaning from that in which they are understood by another, and goes on. But the notion that the same words should bear different meanings to different men, and that more than one meaning should be the, quote, right, conflicts with the whole training of lawyers. Words are the tools of his trade, use them to define legal rights and duties. They do not achieve that purpose unless they can be attributed to them a single meaning as a right meaning. And so the argument between lawyers starts with the unexpressed major premise that any particular combination of words has one meaning. It goes on just towards the end, but it's capable of ascertaining as being the right meaning by the adjudicator to whom the law confides responsibility to determine it. Now, therefore, the contract's meaning is objective. It means what it means. There's no discretion involved. Courts do not rewrite contracts for the parties on the basis that they think is best. And it appears that JF has taken out of context the next bit by Lord Justice Briggs in his dissenting judgment in Credit Suisse case entitled, English law assumes that every question of construction has a right and a wrong answer. In reality, there can often be as much scope for reasonable differences of view as there is in many cases about the exercise of discretion. Well, that's not the point. It's not an exercise of discretion. While we're here, we say, nor does the construction of a contract against its factual matrix involve applying a legal test that requires the weighing or balancing of factors. We accept that in cases where there can only be one correct answer, if the court's decision involves the assessment of a large number of factors, an appellant court should be hesitant to interfere unless the trial judge took into account irrelevant factors or failed to take into account relevant factors. And a good example is as the Aldi Stores case that's in the authorities for abuse of the process or where there's been frustration. You take into account a whole weight of factors. But the proper construction of a contract does not involve weighing or balancing competing factors. The court simply has to determine what a reasonable person in the position of the parties would have understood. So we say none of our appeal in any event involve a challenge to any of the factual matrix or underlying facts in this case. And what we say is the conclusions that the judge reached as to the meaning of the contract, drawn from those facts, were in parts incorrect, and we challenge the judge's analysis, but it's only his analysis, not the underlying facts. But even if I were wrong about that, and if there were any challenge to the underlying facts, that would in any event not involve the test applicable for an appeal in relation to an exercise of discretion, and that's been firmly stated. And if one just turns in the authority bundle to tab 7, you'll see the authority of the Arab Insurance Group case, which produced the practice note. And it's a judgment of Lord Justice Clarke, as his name was. If one turns to page 140, he records the rather bold submission of Mr Boyd about the test on appeal. And you'll see in paragraph 8, he refers to the Tanfern case. And you'll see also in paragraph 9 over the page at 141, he refers to G&G, the two cases my learned friend relies on in his skeleton argument. And then at paragraph 10, Mr Boyd submitted that the same approach should be adopted to an appeal of this kind. However, for my part, I would not accept that submission. As Lord Justice Brooke makes clear, Lord Fraser was considering the correct approach where the appeal is against the exercise of discretion by the lower court. An appeal of the kind which we are concerned with, challenges the judge's conclusions of fact, not the exercise of discretion. So even if I were challenging any of the conclusions of fact of the deputy judge, that still wouldn't invoke the rules in relation to the exercise of discretion and the challenges on appeal. Therefore, we say with respect, we do not need to show that the judge's construction is, quote, exceeded the generous ambit within which disagreement is possible. That's not the test, which is a test my learned friend applies in his skeleton. That deals with the law on construction. I'm going to now move to the 3 main themes of JF's skeleton argument. Now, the 3 themes are, the first one is the correct factual matrix, and in particular, whether the clause 5 indemnity, and can I just pause here? When I say indemnity, I'm like the judge using it in a very loose sense. It's actually just simply a payment obligation. But before and below, the parties found it useful just to call it an indemnity. The question is whether that clause 5 indemnity was a quid pro quo for the repurchase option AF granted to her brother. So my first theme is the factual matrix, and in particular that question. The second theme is the importance of the family context behind this contract. And then the third theme is what my learned friends call the all-pervasive 4-year tenor argument. That the TT agreement, they say, is an interim agreement and only for the 4-year tenor of the Brandon loan. Those are 3 themes, and I'll go through them. Just before I do so, it's appropriate that I just take you at this stage to the Taurus 2 agreement, and you'll find that in the core bundle at tab 8. We're going to be looking at this in a lot more detail later. But if I can just show you the structure of the document. It's a short document. It is in fact only 3 pages long with the signatures on the 4th page.
And I'm sorry, Mr. Hill, it's identical to the appendix to the judgment.
I think it is, though I can't remember if the judgment also had some highlighting or...
It has some underscoring and bold, but otherwise its content should be the same. Is that right?
It certainly should be. And what it doesn't have, though, is the attachments.
Right. Okay.
So I'm happy to work off the one, if it assists, the one attached to the judgment.
Fine. I just had taken out the appendix, and now I will turn to this.
I'm grateful. So it's a relatively short agreement. It purports to be 3 parties, John, Angeliki, and their father, Nikos. It has a section headed background, which are essentially the recitals, going from A to K. So it has 11 recitals. I won't take you through them right now. The only one I'd highlight at this stage is recital G. On the 1st of September 2011, the vessel had been sold by Shipping Fortune and delivered to Brandon. The company beneficially owned by beneficially controlled by Angeliki Frangou at the price of 33.5 million, partly with funds drawn under the terms of a new loan agreement made between the buyer and HSH, which has been secured inter alia by a personal guarantee of Ms. Frangou. The proceeds of the new loan were 26.8 million, and in particular with a 4-year tenor and 15-year profile. And then you have only 5 really operative clauses. The 6th clause is just a law and jurisdiction clause. The 5 operative clauses are the first one, which essentially gives to John the right to repurchase the loan, have it transferred back to him upon the maturity of the 4-year tenor of the loan. The second clause essentially deals with the earnings of the vessel during that 4-year period. The third clause sets out 5 preconditions that have to be fulfilled in order for John to be able to exercise his right to buy back the vessel. The 4th clause just deals with what happens if the vessel becomes a constructive or actual total loss during the course of that time. And then the 5th clause, which is the one obviously we're most interested in, is we say 3 parts. We separated it out in our skeleton argument. 3 parts correspond to the 3 sentences. You have the first sentence, which deals with if the purchase option is not exercised, Ms. Frangou has the right to sell the vessel at a fair market value or to refinance at the best possible available terms at the time in order to cover the then outstanding indebtedness. The second part deals with what has been loosely called the indemnity, that if the proceeds of the sale or refinancing are not sufficient, John indemnifies his sister. And then the third part, which had less attention below before the judge, which is even if she exercises at some stage her rights and refinances, and then the proceeds of the employment of the vessel during the course of such refinancing accumulates profits, then John will be entitled to receive back in full or in part the above shortfall, which would have in the meantime been paid to his sister. That had less focus by the judge below, and I'll say in a moment, and I'll explain why, that should be given more focus. And then attached, your signature page is over the page, and then the attachments are firstly you get an email dated the 26th of August 2011, which set out the commercial terms of the new loan, and it was from the bank, and that was attached to the contract. And then the second thing that was attached to the contract is an acknowledgement of debt, which you'll see at page 145, which is signed by John, dated the 1st of September 2011, and you'll see that he acknowledges the debt, you'll see at the bottom of that page, of some odd 14 million, and I'll come back to that in a moment. And then over the page are the terms of the acknowledgement. Now, if I can deal with the first main theme, which is what is the correct factual matrix? We say it's important at the outset to appreciate that it's John who has to read words into the TT agreement, and thereby, we say, do violence to it, not Angeliki. His whole case is actually a purposive construction based on what he says is the factual matrix and what he says is the commercial purpose of the agreement. And in particular, we say the TT agreement does not say that Angelika shall sell or refinance at the end of the 4-year period. It only says that she has a right to do so. It certainly does not say that AF shall elect or choose whether or not to do so on the 1st of September, as the judge found. It certainly doesn't say that Angeliki can't sell or refinance at any later date. None of those words are in clause 5 or the agreement anywhere. And what we say John needs to do is use his factual matrix for his purposive construction to read into the TT agreement words that are not there. It's therefore, we say, important to look at the correct factual matrix. Now, at this point, the quickest way in which I can do this is if I can ask the court to turn up our original skeleton argument in tab 3. I'm just going to go through paragraph 12 on page 26 of the bundle and take the court to a few of the underlying documents which will help you see the factual matrix. So in paragraph 12, it's on page 26, we set out what we say the relevant factual matrix is, and we say all of it is drawn from the judge's paragraphs 11 to 19, save for 2, and I'm going to highlight to you when I get to them the 2 that arguably are not.
Sorry, am I looking in the right place? This is supplemental bundle, tab 20, page 20.
No, it's a core bundle.
Sorry,
My lord, it's my. I was probably not clear. Core bundle, tab 3, page 26. And I'll just say again, all the relevant factual matrix is taken from the judgment, barring potentially 2 points, and I'm going to highlight those 2 points to you when I get to them. Now, the Taurus 2 was originally owned by John via his company Shipping Fortune. He had financed the vessel by way of a loan facility from HSH Bank, secured by a mortgage against the ship, and importantly, a personal guarantee from him. By the summer of 2011, the loan with HSH was deep in default, and HSH arrested the vessel. And by the end of August 2011, the outstanding indebtedness to which John was personally liable under his guarantee was 47.5 million. And if at that point you can take up the supplementary bundle, and if we turn to tab 16, what you'll see is a settlement and standstill agreement dated the 31st of August, which is the day before the Taurus 2 agreement. And you'll see this is an agreement that he as an individual, John as an individual, and his companies entered into with HSH Bank. And if one turns to page 230, you'll see in recital J, the borrowers have failed to pay certain repayment instalments and other amounts and to perform certain obligations under the loan agreement on the date hereof. Financial indebtedness, ... was 47, just a smidgen over 47.5 million, and that was defined as a loan indebtedness. Now, we say John faced the prospect of financial ruin in his own words, and we've given you a reference to his own statements. The bank had decided to make an example of him. He had no hope of repaying that vast sum, and if he was in default, they would call on his personal guarantee. And if they called on his personal guarantee, this would trigger defaults under various other corporate loans and guarantees that he had in relation to other vessels. So he was in a dire predicament. Now, it's against that background that John turned to his sister, who is a very successful businesswoman in her own right, who single-handedly built up a company called the Navios Group, which you may have seen is the largest shipping company, certainly in Greece. It owns 180 vessels, and she built that up single-handedly. Now, out of family loyalty and at the behest of their elderly father, Nikos, she intervened on John's behalf with the bank and persuaded it not to enforce the debt and agreed to bail out her brother. And the terms of the bailout were as follows. AF, via her company Brandon, purchased the Taurus 2 at a greatly inflated price of 33.5 million when the true value was only 22 million. And that sum reduced John's debt to the bank, leaving a residual liability of 14 million, and that was called by the parties and also the judge below the Stiliani loan. And if one goes back in the supplementary bundle, you'll see that outstanding indebtedness is recorded in recital K.
At 16 again.
16 page, and it's 232. So we've got clause 3. This is the settlement, standstill and waiver section. And under 3.1a, you'll see the bank consents to Brandon purchasing the vessel for, as I said, 33.5 million. It was to be funded by a loan by the bank for 26.8 million. And then, importantly, it's the B. The bank consents to the remaining balance of the loan indebtedness following the application of that purchase price, and they called it the residual amount, to remain outstanding. And you'll remember that is then, so that's outstanding vis-a-vis the 3 or 4 borrowers as identified on the face of the document at 227. And you'll remember I took you to attach to the TT agreement is the acknowledgement of debt.
And I'm wondering why you're working so hard at this, given that these facts are stated in the recitals to the TT agreement anyway.
They are, they are, but I'll take it a little bit more quickly then. But what I want...
the matrix, to the extent this is matrix, you can see it from the agreement itself. It's in the recitals.
It is. It is. I was just going to take you through... I'll move on more quickly. Now, what is important is to make this point. It's my D Roman 2. The father contributed $7.8 to the purchase, comprising an equity contribution of 6.7 million and a requirement by the bank that 1.1 million was provided to pay off outstanding debt.
Well, you say it's an equity contribution to the purchase price. In fact, the agreement simply recites that the money has been paid directly to HSH.
Yes, and if I can come to that, that's going to be one of the 2 areas where the parties disagree about the factual matrix. So I'll come to that.
But does that really matter?
What does matter is that the judge finds, and my learned friends rely on the fact that this contribution of 7.8 million was essentially, in substance, a gift to Angeliki. When it wasn't, it was a gift to John. And we are concerned that misunderstanding of the commercial relationship and how this contract came to being infected other parts of his judgment.
Are you saying that recital I is incorrect?
Of the TT agreement?
Yep.
No, I'm not saying it's incorrect. So, as we've set out in D Roman 2, the father contributed. The remainder came from the purchase price of Brandon. And importantly, the terms...
the remainder came from the purchase price of...
The purchase price paid by Brandon.
Paid by Brandon. Okay.
From Brandon. Sorry, I should have said paid. And you'll see that, and I want to just highlight this bit in Roman 3 on page 27. The Brandon loan was personally guaranteed by AF. The result was that in order to bail out John, AF was left with a vessel which was a depreciating asset in negative equity to the tune of almost 5 million, because it's actually only worth 22 million on purchase. And therefore, even taking into account the loan was 26.8 million, had a loan to value of 122%. Now that's going to become important.
Let's be clear, that's not actually accurate. Page 27. AF was not left with a depreciating asset with a vessel Brandon was.
Correct, Brandon was.
Because when we get to a later stage of these arguments, it would be useful to be a bit more accurate about
That's
who's
fair.
left with what.
That's fair criticism. That's very fair. And therefore, she had a personal guarantee to the bank of 26.8 million because her personal guarantee guaranteed all sums due under that loan. And I was going to take you to the document, but I don't need to. What also is important at this point, Roman 5, that she procured an agreement from HSH that standstill agreement in respect of the residual Stiliani loan, that 14 odd million, was deferred until the maturity of the Brandon loan. And we say, again, part of the factual matrix, AF had nothing to gain from the arrangement set out above and everything to lose, as recognised by the judge. She had taken on a depreciating asset in substantial negative equity in circumstances where she had a personal liability to make a balloon payment in 4 years, which almost certainly would not be covered by the sale of the vessel, and in circumstances where she would never be able to raise a replacement finance in the market.
So just getting it correct, a company of which she was at that stage the beneficial owner, or beneficial owner or controller, had taken on the liabilities in relation under the new loan.
Under new loan, yes.
Which would mature in 4 years' time.
Correct, and she
And she was
guaranteed.
the guarantor.
She was the guarantor for all. It's an all monies guarantee, and she was liable for not only the balloon payment but also for, example, the instalments going along.
Do we have the Brandon loan somewhere in the bundle?
We do. I was going to. I had intended to take you to it, but I was going to. I decided to speed up.
Anyway, that's completely fine. I mean, at some point, I'd like to have a glance at it.
I'll do it now. It's supplementary bundle tab 17. I was going to take you to it at the time, but I decided to speed up. And you'll see the loan agreement is dated also the 31st of August. And I was going to take you to clause 8, which you'll see on page 261. And it's the repayment and prepayment obligations. So the borrower here, Brandon, has to repay the loan 16 consecutive quarterly instalments of 446,000 odd, and a balloon payment at the end of the 4 years of 19.6 odd million.
And just while we're doing document, I'm not sure why it's called the Stiliani loan, but where the document that actually records anything in relation to that, is it a fresh loan document? Is it just a...
It's a standstill agreement, my lord. So if your lordship goes back a tab to the... go back 2 tabs to tab 16.
Yeah.
If your lordship sees the third of the borrowers is Stiliani,
Yes.
and that's why it was, it's been called by the parties the Stiliani loan for the last 10 years. And that is the residual amount, which one sees on page 232, 3.1, small b, the consent then to that residual amount remaining outstanding.
It's 232.
And you'll remember that because John had guaranteed this loan, he entered into that acknowledgement of debt, which you saw attached to the TT agreement, which has the acknowledgement of the 14 million. And the point is just to make here, and I do want to make this point, in 2011, the bank took no haircut. There was 47.5 million odd outstanding, and it did not reduce its debt at all.
Just got rearranged.
Just got rearranged. 33.5 million for the purchase of the vessel, and 14 million went to the Stiliani loan.
And the personal guarantee document signed by your client is where?
You'll find that in tab 19, I think it is. Yes, that's right. The suite of documents are all dated 31st of August. You'll see out page 330, the guarantee is in clause 2.1a.
The guarantor being the ultimate beneficial owner of all shares in the borrower.
Correct. Borrower being Brandon.
Yeah.
Sorry, which page were you taking us to?
330.
3330.
330.
Thank you.
So this suite of documents, all drafted by Watson Farley by the look of it,
That's right.
that you've just shown us, all dated the 31st of August. And we then have the agreement made between John and Angeliki the following day, plainly not drafted by Watson Farley.
No, in fact, and I'll come on to that. It was drafted, both brother and sister have their own in-house lawyers, and they were drafted by their own Greek in-house lawyers. And we'll come on to that and I'll show you.
Yeah.
And the other thing, if I can just clarify, although it's dated the 1st of September, it wasn't signed on the 1st of September. I should say that. And it doesn't matter, it's evidence that came out of trial before. Now, as I said, essentially, there was nothing in this for my client AF, but it was of considerable advantage to John. Now, there are only 2 points in that.
Not that I want to quibble with you at all, nor do I want to delve further into the factual matrix, but it might be said, and I'm sure it is said on behalf of John, that saving the family name had something to do with AF as well as JF.
Yes, I agree, and in particular, the pressure from the father.
Yes.
And I'll come on to that family context because that's prayed in aid, and that's my second theme. It's
Yes.
prayed in aid heavily, and I deal with family context separately. Now, there are 2 points that...
The fact that whether it's right or not, that you say, in the sense that no benefit to your client and all benefit to John, I mean, that's just a subjective interpretation of matters. I mean, your client entered into the contract freely. She's an experienced businesswoman. It is what it is. I mean, the terms say what they say.
I'd have to differ to some extent on that because what we say is you have to read clause 5 and its purpose and what it was seeking to achieve against the factual matrix. And the factual matrix in this case is that she got nothing from this deal. And therefore, when you come to conclude or decide, was there a hair trigger event on the 1st of September, which means she either sells, on my learned friend's case, and gets the benefit of an indemnity, but doesn't, chooses not to, and loses the indemnity, you can take into account that factual matrix, and in particular, whether that's really a sensible construction in the light of she was only in this to help out her brother. And that will become important. Now,
So you want us to set aside what otherwise might be an attitude that people enter into bad bargains and that's their problem.
No. No, I want you to not set aside that. I want you to do the exact opposite. I want you to see this as a bad bargain. There was a reason why it was a bad bargain. She was helping a family context and saving her brother from a bailout. But appreciate that informs the construction of clause 5. Not save her from anything, but just it necessarily informs the construction of clause 5, we say. Now, my learned friend, if you turn up his skeleton argument in tab 4, he deals with the factual matrix at paragraphs 28 to 32. under the heading Critical Factual Matrix. And his first critical factual matrix is the critical family context, he calls it. And I'm going to deal, that's my second theme, so I'm going to deal with that separately. At paragraph 30, he says under factual matrix that essentially the $7.8 million loan was in substance a benefit to AF, a parental gift or windfall in substance, and that's just wrong. And in fact, the judge got it wrong. And it perhaps shows that the judge didn't fully grasp the...
Sorry, I'm struggling to see where you're reading from.
Paragraph 30 of my learned friends, it's the last sentence. AF did not need to do that on any of her three hypothetical exit routes. Yeah. So if she retained ownership of the TT after the Brandon loan matured, she was in substance the beneficiary of a 7.8 million parental gift. And footnote 19 is a reference to the judgment, and that is what the judge found, and that's just wrong as a matter of analysis. And we think that did play heavily in the judge's mind.
Well, I mean, what happened, as I understand it, was that father contributed a sum of money which encouraged or facilitated the release by the bank of its right of arrest and security over the vessel, which enabled it to be sold to Brandon, a company wholly owned by your client.
That is correct, but then I'll deal with it now. But the vessel was bought for $33.5 million when it's worth, at best, $22 million.
Yeah.
So what then happens is...
I mean, it is, you know, I mean, it would be wrong to say, I think, at least as I understand it at the moment, that the father's 7.8 million was a gift to your client.
Correct, because
but
she's already paying. So she takes out a loan. Oh, sorry, Brandon takes out a loan for which she guarantees. The loan is taken out for 26.8 million for a vessel that's worth 22 million. So she's already, as it were, gifted to her brother almost $5 million. Now, if her brother does not repurchase the vessel from her, it isn't in that 7.8 million isn't in substance a gift to her. She can't in any sense benefit from that. All that did was reduce the residual outstanding indebtedness under the Stiliani loan to the bank. She doesn't get any benefit out of that because she's actually still left in 4 years' time with a balloon payment of over $19.6 million for a vessel at that stage that will not be worth $19.6 million. She can never realise any value out of that 7.8 million transferred by the father. And therefore, the judge was just wrong when he perceived the family relationships here and perceived it as being a parental gift to the daughter if the son didn't repurchase the vessel.
Would you say, I mean, an indication, that's rather a strong one, that the primary beneficiary of the contribution from the father is that the specific term that if the son exercises his option to repurchase, he then has to repay the...
Correct. And that was my next point, which is if one looks at the TT agreement, under clause 3, he's got to pay back that 7.8 million.
Yeah.
If he wants to be able to repurchase the vessel. And if he doesn't repurchase the vessel, essentially the father, I suspect at that time, thought, well, I've lost that money. But it certainly isn't a gift to Angeliki. Now, that's helpful because I've now dealt with the first...
I'm not entirely sure how that helps us with the interpretation. I mean, one of the problems in this case is that if we start chipping it away at individual bits of comments here and there made by the judge as part of the matrix, I'm not sure we're actually focusing on the real question, which is what the agreement means. And I'm just speaking for myself, I think it's much more helpful actually just get there a bit quicker.
I anticipated this might happen, and I have given, can I just say this to the court? I have given a lot of thought about my submissions.
So you did, to be fair, you did warn us that we should let you
patient.
get on with the indication.
I've given a lot of thought
I
to
will.
this, and I've discussed it a lot with those behind me. We do feel that we need to spend an hour or so setting the scene on some important matters, because the construction point is actually very short, and it's not going to be time wasted.
I'll-
So, but no, I am not suggesting that. But trust me that I have given some thought to this. Now, the second area where the parties do really differ on, and it is perhaps much more focused on the construction of Clause 5, is whether the indemnity in Clause 5 was a quid pro quo for, as my learned friend and the judge finds, which is giving John the repurchase option, or whether, as we contended below and contend on appeal, that it was a quid pro quo for entering into the bailout at all. And that is important because you'll see in a moment, well, in about an hour, the judge relies heavily on that when he comes to construing Clause 5. And if I can just take you at this point to my learned friend's skeleton argument, I mean, the core bundle tab 4, page 10, under the heading Critical Factual Matrix, he deals with the family context, and then under other context on page 11,
Or 58 of the bundle, yes.
page 58 of the bundle,
Sorry. 58 of the...
of core bundle,
Yeah, on there. So which paragraph?
32.
32.
Sorry.
What he deals with there is other critical context, he says, or other context. And you'll see in C, despite peculiar benefit of the TA to JF, he was hurt by the loss of the TT and wanted to buy it back from AF. The first draft of the TT put together by JF only made reference to what became his Clause 1 buyback right. AF responded with a draft that included what was to become most of Clause 5, absent Part 3. And then over the page, it's agreed between the parties, both brother and sister had the benefit of advice from their long-standing in-house lawyers in connection to negotiation and drafting, and that is agreed.
And we're not interested in negotiations.
No, and this is my point, because if one then goes back to...
And just out of interest, I mean, the comment that JF was hurt by the loss of TT, I mean, is that actual factual matrix? I mean, it may be common ground. I don't know whether the judge's comments in that respect are common ground, but I mean, that's a sort of subjective feeling of one party. I mean, it's not normal contractual matrix.
To be fair to my learned friend, I think it is common ground that what was focusing, he did not like the fact that, and no disrespect to John, that his more successful sister had taken the vessel and that she now owned it, and he wanted to, at all costs, get it back. And that was a strong feature of the evidence below, it is fair to say. Now,
It's part of the general family matrix.
all part of the general family matrix. Now, in 32C, he referred there to the negotiating context. And if I can take you back to paragraphs 14 and 15 of his skeleton argument. In paragraph 14, he says, the judge, having heard oral evidence on the topic, determined that, and then he sets out again, A, B, C, how the document was negotiated. And then he says at 15, Angeliki alleges that the TTA was primarily a quid pro quo for the bailout. As the latter citation expressly accepts, those submissions are contrary to the judge's factual finding about the genesis and context of both the TTA generally and to the interplay between clauses 5 and 1. The judge made those findings, classic factual matrix, I disagree with that, but after having heard the totality of oral evidence from 4 witnesses across 3 days, and he complains, with no disrespect to my learned friend, that we can't now go behind that finding. And he says, in fact, at its highest, Clause 5, this is the bottom of that paragraph, the quid pro quo for the Clause 5 was a quid pro quo for the conclusion of the TTA, which had at its core John's Clause 1 buyback right. this is the key internal dynamic of the TTA that drives its proper interpretation. I just need to deal with that. Now, it is right that at paragraph 20 of the judgment, the judge briefly describes what he calls the drafting history of the clause. But if one looks at paragraph 20, it's actually very anodyne.
Well, it's more than that, isn't it? He makes it quite clear it is, strictly speaking, irrelevant.
Correct.
I mean, he could hardly say it more clearly.
Correct. And what we say is that how that agreement came apart together and what each party was expecting to see is entirely irrelevant. Entirely irrelevant. It's evidence of negotiations, and we say it's inadmissible. Even if it were admissible for some limited value as some sort of chronology, it tells the court nothing in terms of what the clauses mean. The court cannot extrapolate, we say, anything meaningful from it. It's only when the parties seek to give evidence of their subjective intentions for why certain clauses were introduced that the matter moves forward. But those subjective intentions are not only irrelevant, but certainly inadmissible. Now, this is what JF is seeking to do by arguing that the judge's comments stem from having heard oral evidence. What he's simply trying to do is rely on subjective intention as to the purpose of each part of a clause. And we say that is illegitimate and you cannot construe a contract in that way. And we also say the judge did not do so. So he's overstating what the judge did. Now, what is clear, and it's interesting that at this stage of the judgment, under the heading on page 118, relevant background, the judge is setting out what he says is the critical factual matrix. If one then goes on to paragraph 73, Roman 6, which you'll see on page 129, part of what the judge does when he comes to construing the contract is one of the reasons why he finds against my client is he says there is no evidence or suggestion that JF sought a longer period to buy back the TT. Clause 5 operates only where the buyback option has not been exercised by JF. In a sense, it is a consequential or secondary feature of the TTA. If JF did not want or expect longer than 4 years for his buyback option, it is unclear why or how AF could legitimately expect an indefinite indemnity in respect of her unencumbered decision as to the fate of the vessel after such 4-year period. This feels the wrong way round in terms of the genesis of the bargain. Now, that really did affect the judge, because what he is essentially saying there, and he says elsewhere, is he says, well, look, you can't have had an unlimited indemnity under clause 5, because John's buyback option is limited to 4 years. And essentially, the indemnity was a quid pro quo for the buyback option, and therefore the two run hand in hand. And therefore, if you can't have a longer period unless he gets a longer period for his buyback. And that's very much what you get, and that's what my learned friend develops in his skeleton argument.
At the moment, it seems to me it's a complete non sequitur. I mean, the fact you have 4 years for a limited right to buy back the vessel is one thing. What then happens, we just have to try and work out by looking at the contract for what it says. And on the face of it, there's no time limit at all. Correct.
They're absolutely correct. And can I make one other point? So I adopt that. But making another point is this. Even as a matter of analysis of that whole concept, it doesn't work. Let me say this. The indemnity or payment obligation responds to an exposure suffered by AF, Angeliki. The losses for which the indemnity responds are shortfall to the bank or operating losses. Those losses for which the indemnity provides do not mirror the sort of losses that could arise from JF exercising his buyback option. And let me just give you an example. Logically, if the clause 5 indemnity were linked to John's repurchase option, then it should respond to losses that Angeliki would incur if she was forced to sell the vessel back to JF during the 4-year period. Let me give you an example. What if the vessel had been increasing in value during the 4 years, during the 4-year option period, such that, say, for example, in year 3, it's worth more than $26.8 million, i.e. the loan value. AF perhaps would have sold the vessel in year 3 for example, 30 million, and paid back HSH and made a profit of 3.2 million. But because of the repurchase option granted to JF, she's prevented from doing that until the end of the 4 years. And then you get to year 4 and say John does or does not exercise his repurchase option. Then I can see that you might want an indemnity to indemnify her for her losses because John has that repurchase option, her losses of 3.5 million. That would make sense. But if you look at the losses in clause 5, those aren't those sorts of losses. The losses don't mirror the purpose for the indemnity. And that's why that whole analysis of the judge is, we say, with respect, wrong. And my learned friend plays it heavily in his skeleton argument, but we say objectively it makes no sense. Objectively it makes complete sense, looking at the type of losses the indemnity responds to. It makes complete sense that the clause 5 indemnity is a quid pro quo for her taking on the personal liability of her own personal liability and her company's liability in the first place. It's the bailout.
And in a way, of course, factual matrix is important, but one can achieve or get to that point, Mr. Hill, by just looking at the TT agreement as a whole and considering clause 5 against the earlier buyback clause and see their terms. You don't have to go any further than the 4 corners of the
agreement. 4 corners, yes, because you can just rely on what the loss is, what the indemnity responds to.
Exactly, what the wording is.
What the wording is.
That's
so
it.
That's my first theme done. My second theme is the family context. As you will see, my learned friend submits that the family context is critical to the agreement. We accept that a relevant piece of factual matrix is that this was an agreement between brother and sister, which involved a bailout of the brother by the sister at the instigation of their father, or at least encouraged by him. We accept that fully. And that is what the judge finds in paragraphs 13 and 17 of his judgment, and also at paragraph 9. But we say that's as far as it goes. There is no special law about interpretation of contracts between family members, as you all know well. And I hesitate to do this, but I'll read it into the transcript. If you look at Lewison in the authorities bundle at paragraph 2.30, the theory that a contract has only one meaning is pervasive. Thus, there is only one system of interpretation. And in particular, paragraph 2.33, that although there are no special principles applicable to the interpretation of particular categories of contracts, the nature of the contract may influence the relative weight to be given to the context.
I mean, the fact that it's a family, there's a family context, explains why your client would enter into an agreement that if there were no family context, you might think she would be barking mad to have done.
Correct. And I'm going to make that, I won't now, but I was going to make that very submission.
In the sense that, but I think in a sense it's accepted that somebody who had, in fact the judge does accept that, somebody who had no connection at all with JF would be very unlikely indeed to have entered into an agreement on these terms.
The vessel was immediately underwater from the moment you take the loan.
But once you get beyond that, I think your point is that's as far as in a sense you can take it, because you then have to look at whatever they agreed.
Correct. I'm going to make a few more points, but essentially that's correct. Before I do, there is a very recent decision of this court. It's called Contra Holdings. It's a 2023 judgment. It's in tab 15 of the authorities fund. And there is a very nice statement by Lady Justice Capt in relation to construing contracts in a family context. It arises, it's tab 15, it arises out of the dispute between the Bamford family, who own JCB Diggers. And they fell out in quite a significant way. And the agreement that they had reached was an agreement called the Touch Agreement. And you'll see that on page 343. It's a very short agreement, actually not dissimilar in terms of length to ours. And the court had to construe the Touch Agreement in a family context. And in page 344, paragraph 12, Lady Justice Carr records the judge's submissions on contractual interpretation. In fact, they were perfect and she didn't need to reset them out again. And then what she says at paragraph 25 is this, discussion, under the heading discussion. Whilst not lengthy or drafted by lawyers, the Touch Agreement is nevertheless a logically structured and largely clear document. Just pausing there, that's exactly the same with our case, we say. The ordinary rules of contractual interpretation apply to it. It is right that context may have greater than usual weight when interpreting a more informal document, something which the judge had well in mind. But informality is not a trump card that can overturn a text that carries an obvious and clear meaning. We say the same here. There are also degrees of informality, and the Touch Agreement was a careful, albeit brief document drafted by a qualified lawyer.
Accountant.
Sorry, accountant, I do apologise. And then at paragraph 31, at page 349, and this is, I would just urge this court to adopt the same approach. It's common ground that the exercise of interpretation must be carried out against the relevant factual matrix. However, it must also be remembered that it's not permissible to construe from the background a meaning that the words of the contract will not legitimately bear. The background should be used to elucidate the contract, not to contradict it. And we say those words really do apply very much to this case.
Another aspect not relevant here is that in some contexts, the fact that a family deal of some kind is reached can be a signal or a reason for concluding that there was no intent to create legal relations at all. But obviously we're not in that territory. Whatever you say about this particular contract is quite plainly intended to have full contractual force.
And it was drafted by lawyers. In-house lawyers on both sides drafted this contract. Now, we therefore say my learned friend goes too far in his skeleton argument at paragraph 31. At paragraph 31 of his skeleton, he says the court should, quote, pause for thought before one approaches the meaning of the TTA and its protagonist's actions or inactions through the lens of normal commercial actors. And he says it's very risky in this case for anyone involved to arrogate to themselves overconfidently the role of arbiter of commercial reasonableness or likelihood. And we say that's going too far. My client was an extremely successful businesswoman whose very role, her role was to come in and use her business acumen and relationship with the bank to refinance the debt. That was her role. JF himself is an experienced businessman in his own right. The Taurus 2 was not his only asset. He was at pains in the trial below to tell the court of his other business dealings. He faced ruin as a businessman because if HSH enforced the personal guarantee, it would trigger foreclosure elsewhere. My third point I've made, which is...
I mean, just out of interest, I mean, that reference is a reference which warns against the danger of the court refashioning the terms of a contract to, because it seems to the court to achieve a reasonable or some other such outcome.
Correct.
So it's just, I mean, it's not objectionable in the sense that those words are really just saying you are here as a court to arrive at the true meaning of the words that the parties used in the relevant context.
Correct.
Just don't remake the bargain.
Just don't remake the bargain. And my learned friend seems to be saying in that paragraph, because it's special family context, we've got to be very careful about looking at commercial purpose or commercial common sense. Now, the reason he says that is because his construction, and I'll come on to this in a minute, requires this hair trigger event on the 1st September 2015, where use it or lose it, as it was described in the below. Either you use your right to sell and get the indemnity, or you don't and you lose your indemnity. And that has, and I'll come on to it, perverse commercial consequences, and it makes no sense. And what my learned friend is trying to do in that paragraph is invite you not to really look at the commercial sensibilities of his construction, because he says it's all a family context. So just finishing up on that point, we say to suggest that this is purely a family arrangement is wrong. Yes, it has a family context, but what's more important is its financial and commercial context of the agreement. This was a commercial deal between two experienced business people. And you should...
To the extent that one can take it into consideration, this is a family context, but also one must not lose sight of the fact that A, it was drafted by in-house lawyers on both sides, but B, both parties in the sense of brother and sister, and I ignore for this purpose Brandon, but one shouldn't, were also skilled commercial people.
Yes.
So you mustn't lose sight of that.
And that's my submission.
Yeah.
And a point, my next point was going to be, you've still got to test in the iterative process of construction. You still have to test my learned friend's construction against what a reasonable, rational actors would do and whether the agreement makes practical sense. And it's a point my Lord Justice Snowden has made. But for her father and brother asking her to do so, no sensible business...
Just pause there. I'm not sure that's what you do. You don't say what would a reasonable actor do. You say what would these words mean to a reasonable, objective person reading the agreement.
Sorry, let me just be... I do apologise. Let me be a bit more clear on that. What I'm saying is when you're testing your constructions as part of the iterative process, you're entitled, when testing your construction, to say, is this something that a reasonable, rational actor would do? Now, because if it plainly isn't, then it should give you cause for concern, and you would expect to see pretty clear words that they intended an uncommercial or irrational result. That's as far as I put it. That's as far as I put it. And I was just going on to say, AF was being asked by her brother and father to do something that was not a sensible business proposition. And that is important. There was no prospect of this vessel generating sufficient income over the 4 years to pay back the balloon payment. Therefore, at the time they entered into this contract, they knew that something would have to happen in 2015. Something would have to happen. We say that loan would have to be restructured with HSH at the time or refinanced by another lender. Now, obviously, a restructuring with the existing lender was always the more likely outcome. And I say that simply because where an asset is heavily leveraged, as here, with a loan to value of 122%, a new lender will not wish to take on such an exposure. And it's no answer to sideline such important factual context by saying this is simply an informal family arrangement.
But we've been listening, as you say. You've been doing, as it were, a reply before we actually get to the terms of the contract, which is. The position is that everybody understood that there would be a 4-year term reached of the bank loan to Brandon. And at that date, there was the opportunity for, subject to conditions precedent, for JF to purchase the vessel, or indeed it's probably actually, is it him or his company, actually, to repurchase the vessel from Brandon at a price which was stated by one of the conditions to be the minimum outstanding indebtedness of Brandon to the bank. In other words, which would get Brandon off the hook and the sister off the hook.
Correct.
And that's made explicit because one of the conditions is D, that the personal guarantee be cancelled and she be released from her obligations. And one of the other conditions as well, Sir Launcelot Henderson has made clear, is also the repayment of the £7.8 million to father.
Correct.
So that's one possibility. And then clause 5 is to deal with if that hasn't happened.
Correct.
But we're therefore at the stage at which we know that there's an existing bank indebtedness from Brandon to the bank, a personal guarantee in existence, and Brandon continues to be the owner of the vessel.
Correct. And there's only one other thing I'd mention as well, which is outstanding operational losses, because of course both 3A requires John not only to make good the Brandon loan, but to also any shortfall from the operational management of the vessel. And at that time, it was well known in the market that the market was on its knees, and in fact this vessel wasn't able to even cover its quarterly capital repayment and interest. And in fact, Brandon, by the end of that 4 years, was nearly $5 million in debt to Angeliki's management company.
But that's not, sorry, a lot of that can't be relevant to the interpretation of the agreement.
Well, the figures can't, I agree, but the anticipation that there will be operating losses can, because clause 3A, and I'll come on to it in a moment, 5, they mirror each other. They anticipate that there may well be operating losses, and they have to
we need to be careful, because the trouble is just by making these very fluid submissions that sort of float around. Sorry, that wasn't a pun, but that sort of drift. That's also not.
No, not a pun.
Mix.
Deep water now.
That mix what would have been foreseeable and what's obviously foreseeable as a possibility, which needs to be catered for in the agreement, with events that actually then transpired. Again, is something that we really need to avoid.
You're absolutely right. Well, I put it no higher than it was anticipated at the time by the parties that there could be operating losses.
Yeah, which you can see.
From the document.
And in a sense, the parties were therefore concerned not just to throw their hands up and say, "Well, it doesn't matter." There's a mechanism to deal with them.
There's a mechanism to deal with it.
Mattered.
Correct.
So beyond that, I'm not sure, in a sense, why we need to start getting unduly distracted by notions of familial or context. I mean, the parties were not disinterested in the financial consequences of this arrangement. They make express provision for it. We're not, I assume, speaking for myself, I wouldn't assume anything to the contrary.
We agree with that. The only reason why I think one needs to just consider it a little bit more is because I go back to my point that you have to test the constructions. And what my learned, let me deal with it this way. My learned friend's construction involves a hair trigger event. There's no getting away from that. On the 1st September 2015, he says AF has to sell or refinance. And if she does on that day, and I'll come on later to the way you put it before the judge, if she does, she has the benefit of the indemnity. If she doesn't, she loses that indemnity forever. Now, what we say is, let's just have a look at this practically. John fully accepted at the trial below that if she had sold or refinanced on that 1st September 2015, he would have no defence to a claim for an indemnity. That was accepted. And the losses were, evidence of the losses at that time were 15 million. And therefore, he would have to have paid $15 million to his sister if she had done what he says she should have done to keep the indemnity. Now, what happened, and I'll just read into the transcript that was the evidence of our financial controller, and it wasn't challenged in cross-examination, and it's in the supplementary bundle at tab 14, page 207.
So you say you're going to read into the transcript.
Sorry.
Are we actually getting a transcript, or are you just reading rather too fast for me to take a note?
I'm probably reading too fast because I've been told there isn't a transcript.
Right, okay. So
it's tab 14, page 207. Let's just have a quick look at it now so that you can see what happened. If one looks at the evidence of
Are we not running ahead, though? Should we do this in the sense that this is all post the event? We're looking at the circumstances which pertained when the TT agreement was entered into, and what a reasonable person reading those words would mean. So whether there was a 15 million debt or not in 4 years' time, how does that really help us?
Okay. I appreciate.
I feel as if we're beginning to again diverge.
To some extent, I agree with that. The only way place I wouldn't agree with that is, again, you go back to testing the commercial sensibilities of reference construction.
But you can test. Sorry, I want to intervene in just a second to try and speed this up. You can test that by saying, test it. If there had been a sale on the same date of the 4-year maturity by Brandon of the vessel, triggering various losses, it would clearly trigger the indemnity. You can do that as a matter of looking at the agreement and saying its interpretation. What Mr. John Frangos said in evidence about that is irrelevant.
No, I agree. I wasn't going to take you to his evidence. I was going to take you to the financial controller's evidence to show you the figures. But
that's even more irrelevant.
Yes.
Well, let me. I take that criticism on board, and that's fair. Well, let me follow the line that my lordship's taking, which is to test the rational, the commercial sense of my learned friend's construction. What he says is, it doesn't matter what the figures are. You could have a loss on the 1st of September 2015, which is very, very large. Do you have to trigger that loss, crystallize that loss, as the only way of securing your indemnity, the right to repayment? Or if you have an option where you don't have to trigger that loss and immediately crystallize, in this case, a $15 million loss, but you can, as it were, kick the can down the road until the bank gets its head around the fact that it's going to have to write off some of this debt. If you do that, did the parties really say, well, no, on that basis, you lose your indemnity? And that's what this is all about. And my learned friend has to say, and I'm afraid this is where it comes to, he has to say, yes, she had to crystallize that loss, even if it would be more punishable to my client, because it's a family context, because that's the deal that was done. And he accepts, and he realizes it's unpalatable and it's an irrational thing. And he explains it away by saying it's a family context. And all I say is, that's no answer.
Furthermore, one might think that if the family context were relevant at that stage, it bit the other way, in the sense that one would keep the can going down the road in order not to crystallise the loss, in order not to require brother to indemnify sister.
Indeed. And I think I'm probably going to say the same as my lady, but in a slightly different way. What I was going to say is a good example of when the family context does work in this case, and where it sits happy with the rules of construction, is when you look at the inevitable legal effects of each side's competing arguments. Now, as I've explained, John's construction says there's a hair trigger event on the 1st of September 2015, use it or lose it. His alternative construction is that he says, well, sorry, his construction says that you have that because otherwise John would be giving a unlimited in terms of time and money, an unlimited indemnity, potentially up to full further 11 years left on the vessel. And he says that's completely irrational, it's uncommercial, you wouldn't give an open-ended indemnity. And what we say is the court has no choice. It has to essentially choose between those two constructions, what appears objectively to be both, in some sense, an unpalatable outcome. You either have a hair trigger event on the 1st of September, or my learned friend says, you have this unlimited indemnity potentially going for 11 years.
Well, there are, I mean, we're looking now, I mean, speaking for myself, I'm just focusing on Clause 5 here. There are a number of words which, if we start looking at Clause 5, we ought to start talking about. One of which you've already flagged, which is that it's a right given to Angeliki Frangou to sell the vessel. In fact, it's not hers, it's Brandon's. But anyway, putting that aside for a moment. But it says at fair market value or to refinance at the best available terms at the time in order to cover the then outstanding indebtedness to HSH under the new loan. We need to start talking, rather than in generalities, about the words that the parties have actually used. What do they signify? So at some point, you know, you're, I assume, going to get on to the exercise of contractual interpretation rather than getting around the edge, because I'm perfectly happy to accept, indeed I'm quite keen to investigate the consequences of the rival interpretations, because that's the iterative process that everybody normally does.
And I was just dealing with that iterative process.
But well, you don't normally do it through a sort of invitation to start looking at evidence of various people as to what they might or might not have thought, you know, given a trial about events after the contract was entered into.
I completely agree. And what I'm doing at this stage is just dealing with the family context. And I'm saying, with the choice that is facing the court,
you say family context, actually forget family context. We are where we are, these are commercial people, you look at the commercial consequences of the rival interpretations.
Not quite. Because what I'm actually saying is, I can pray and aid the family context, because if you're going to have to choose between those two rival constructions, what I say is the family context now does help you, because there is no halfway house. You either have to say it's an unlimited indemnity, or you have to say it ends on the 1st of September 2015. And it is in this family context, that is in this situation where the family context becomes important, because it is between brother and sister. It is a case where the brother asks the sister to come in and solve this problem for him. It is the case where, and it's part of the family context, where the brother says, I have the perfect person to do this job. And we've set that out in our skeleton. He actually said, I trusted Angelika completely. She was the best person who could solve this mess. And therefore, when you're coming to construe the contract and choose between those two rival constructions and which is the more likely or more rational, that's where the family context does come in and say it's not irrational that there should be an unlimited, what appears on the face of the document to be an unlimited indemnity for the rest of the life of the vessel until she can find a sensible time to sell or refinance, because in that sense the family context explains why he would agree that. That's all I wanted to say on that point. There's one more point on family context, coming from the wording of Clause 5. You'll remember I said that there were 3 parts to Clause 5, reflecting each of the sentences. And while we're talking about family context, I just want to mention the 3rd sentence. So the 3rd sentence, it's 4 lines up from the bottom of Clause 5, says, however, if the vessel will be refinanced and the proceeds of her employment during the course of such refinancing will be able to accumulate profits, then John will be entitled to receive back in full or in part the above shortfall, which would have in the meantime paid to Angeliki. And that is, again, we say an important indicator to how you view this contract as a whole in this particular clause. What it does is it says that even if she exercises her option and sells, well, refinances, because if she sells the vessel, leaves her. If she refinances and then takes on the risk herself, but triggers the indemnity, what then happens is that if she then, for the next 5-10 years, trades the vessel and makes a profit, she has to pay back that profit to her brother to the extent, until such extent that it extinguishes any indemnity he provided under the second part of the clause.
Yeah, I mean, it's just your point. On any view, that clause, that part of the clause shows the parties are envisaging a temporal scope for the agreement, which can stretch many years into the future.
And that was my...
Absolutely in no way tied to
the 4-year tenor of the loan.
September 2015.
Correct. And that was all I wanted to say now. Sorry it took so long on family context. The only other overarching theme I want to deal with is this all-pervasive 4-year tenor argument. And again, I know I'm not going to, at this stage, be looking at each sentence or even the words of Clause 5 in particular. It is important to see it in the context of the agreement as a whole. My learned friend says, in paragraph 41 of his skeleton argument, he's saying that the only time horizon in the whole TT agreement is the 4-year tenor of the Brandon loan. And he says in paragraph 41, John's essential point is that save in the limited eventuality of part 3, clause 5 clawback, which we've just looked at, the TTA was always envisaged to fall away, its purpose having been completed after 4 years.
Well,
Now,
I mean, my lord's point he's just made is relevant to that, isn't it?
Well, correct. But can I just show you what the judge says also on this? Because the judge this was my learned friend's submission below, and the judge accepted it. If one looks at the judgment, at paragraph 41, the judge says, it calls it an interim agreement. The judge describes the agreement as an interim agreement on its face. It regulated the fate of TT during the ensuing 4-year period, referred to throughout as a 4-year tenor. So the judge describes it as an interim agreement. We say that's wrong. And at paragraph 56, towards the end of the paragraph, he summarised the arguments, and he says the last sentence, indeed, on this analysis, the TTA as a whole expired or fell away in that moment. That's on the 1st of September 2015, as there were no other substantive terms capable of surviving or operating. So the judge and my learned friend both saw this as an interim agreement.
Hang on, he's only, wait a minute, he's only, sorry.
Sorry.
I think my lady's about to
No, after you.
make the same.
I am.
We're about to make the same point in stereo, I suspect.
He goes on.
Sorry about the stereo.
He goes on to make that good later.
He's
in
just
paragraph
summarising.
70.
He's just summarising the rival positions of the parties in this paragraph, isn't he?
Correct, and then essentially, sorry. Sorry, I was going to say, essentially in paragraph 70, he adopts that, and that's the effect of what he construes. And what we're saying, what we submit, is the agreement nowhere says it's an interim agreement or it falls away. And nowhere does it suggest that there are no surviving terms. And what we say is that all stems from a misunderstanding about the references to the 4-year tenor of the loan. If one takes up the agreement, the 4-year tenor of the loan is mentioned 4 times in 4 different places. It's mentioned in recital G on the top of page 140. And it simply confirms that the actual Brandon loan was for 4 years, even though it had a 15-year profile. So recital G doesn't assist at all. If one then goes to clauses 1 and 2, what what it does there is those clauses refer to the 4-year tenor of the loan, but only in the context of John's right to repurchase the vessel. So what we submit is that clauses 1 and 2 don't assist the court at all in understanding what the longevity of the indemnity in clause 5 was. The references to the 4-year tenor of the loan, once in clause 1 and twice in clause 2, simply is circumscribing John's right to repurchase. Clause 3 then just deals with, as we say, the conditions precedent to the buyback. Clause 4 uses the words "in the meantime."
But they are, sorry, just to pause, they are important conditions, though, aren't they, to your argument?
Yes.
I mean, because they signify, as I understand your argument, they signify a clear intention that if John is to get the vessel back at the end of the 4-year term, he has to ensure that, in a sense, the parties are restored, made whole, in relation to the assistance that they gave him on the bailout.
Correct. And in fact, yes, and in fact, what's significant, I'll come on to this, but I'll do it now, is that clause 3A requires John to make up any shortfall in relation to the loan, the Brandon loan, and pay any shortfall from operation and management of the vessel from the 1st of September 2011. So if he wants to buy it back, he has to do those two things, make whole in those respects. And they're mirrored in clause 5, because if he doesn't buy back, he still has to do the same two things. He has to, if she sells and sells or refinances, he has to make up the shortfall on the loan and indemnify in relation to the operating losses, the accumulated losses. So whether he exercises his buyback option or not, and I think this is the point my Lord Justice Snowden's making, is he's got to make her whole, whichever way round it works. And therefore, the indemnity can't actually be a quid pro quo for the purchase option. It's actually the quid pro quo for entering into the whole agreement and the bailout. And just finishing off then my point about the 4-year tenor of the loan. Our submission therefore is clauses 1 and 2 don't assist at all with, in that sense, working out the longevity of the indemnity in clause 5. I've just dealt with clause 3. Clause 4, I'm just picking out all the words in the contract that have a time scale. Clause 4 said, should the vessel in the meantime, and that's just dealing with, we accept in the meantime whilst she hasn't been sold or refinanced, and there is a right of repurchase. It deals with the situation, what happens if the vessel becomes an actual or constructive total loss. Again, it doesn't assist in construing the longevity of the indemnity. And then you really only get to clause 5. And it's clause 5 is the only clause that actually deals with the indemnity or can in any sense put a limit on the longevity of the indemnity. And for all the reasons that I'll come on to now, nothing in clause 5 caps the longevity of the indemnity. Now, if I can just deal with some introductory comments on clause 5. we say clause 5 must not be looked at in isolation. It's necessary to consider the structure of the agreement as a whole. And clause 1 interrupts the default position following the bailout. The default position is Brandon buys the vessel. Brandon and its controller, Miss Angeliki, can do as they wish with the vessel. It's their vessel now. And what clause 1 does is interrupts that default position and requires Brandon to essentially remain as the outright owner of the Taurus 2 and to consent to a sale back to John for a time-limited period of 4 years. And then following the expiry of the clause 1 option, John's option, the first part of clause 5 reinstates the status quo interrupted by clause 1 and simply does no more than say Angeliki has the right to sell or refinance. It simply restates or reinstates the default position.
And I imagine you place some reliance on the point that in the fourth line the words are at the time rather than at that time.
Correct. And that's going to be, well, on that point, my learned friend Skeleton makes a bit of a home goal because he misreads the clause and says at that time. And that is wrong. It's at the time, and it's at the time of refinancing.
Yeah, that's obviously, on the face of it, one would expect that wording to have been chosen with some care to make it clear it is not a reference back to the end of the 4-year tenor, but rather a reference to the time when Angelika decides to exercise one of her 2 rights.
Correct, and there's a symmetry in this because if she sells, she has to sell at a fair market value. So that can only be the fair market value at the time she sells. That's all it can be. And because if she refinances, all the parties are trying to do here is to mirror that type of care in saying, well, it's got to be a refinance at the best possible available terms at the time of the refinancing. What these 2 provisions do is to make sure John's being treated fairly and he gets a fair market value for the vessel or the best terms, fair terms at the time of the refinancing. And it's not the value as at the 1st of September 2015 or the best term financing terms at the 1st of September 2015.
It's a classic sort of protection for a guarantor that the asset will be sold at the best price reasonably obtainable in the market so that the guarantee is called for the lower amount or the least amount. I mean, so that the person holding the securities normally can't just take a laissez-faire attitude to sale on the basis that they can get the balance from the guarantor.
Correct.
That's what this protection is about, you say.
That's the set part 2 is exactly that. It's not trying to limit the longevity of the indemnity. It's ensuring that the indemnity is properly exercised in that, yes, you get an indemnity, but only if you sell at the fair market value or you refinance on the best available terms.
At the time.
At the time.
Yeah. So you've got 2 options, both of which require you to be careful when you're selling, and presumably what would happen if there was an allegation that the market was that the vessel had been sold at an undervalue or the refinancing was on poor terms, the indemnity would be reduced accordingly.
Correct. And if the parties had wanted to say, look here, we have this is an interim agreement. It only covers the 4-year tenor of the Brandon loan, and you have to do something on the 4-year anniversary if you want to keep my indemnity. then you would expect to find language somewhere in the clause. You'd expect to find it in clause 5 that says Angeliki shall sell, will sell, and JF will indemnify or reimburse, will pay the sums. But you don't get language like that. What you get is part 1 reinstating her default position, which is she has the right to sell. All part 1 does is make clear that the restriction on her rights to sell have now expired at the end of the 4-year tenor.
And the protection for John lies in the twin requirements. If she sells, it has to be at a fair market value, and if she refinances, it has to be at the best possible available terms.
Correct. And what my learned friends are asking you to do is to read into this that she has to do one or the other on the 1st of September 2015. And if she doesn't do that because she manages to persuade HSH to kick the can down the road, she gets nothing. She loses the indemnity, which is essentially reflected in the conditions of clause 3A and clause 5, i.e. whatever happens, she will be made whole.
I understand sale at fair market value. I think that's fairly straightforward. You just say Brandon sells whatever the vessel commands in the market, and it applies the proceeds of sale to the reduction of the indebtedness to the bank under the new loan, and if the new loan is not then paid off, John is on the hook for the shortfall. Yeah. I mean that's using the words of the language. What would the parties have envisaged by way of a refinancing, and how does that work?
Well,
I mean, refinancing in what way?
Now, refinancing, our primary submission is, and this might be said to be a concession I made, but I think it's probably fair. Refinancing, normal language, involves going to a new lender, because restructuring normally. Now, I'm very happy if my Lord Justice Snowden doesn't think that that's the right way of looking at it.
Well, even if you go to your existing lender, the existing lender may technically put in place a new facility to replace the old.
Yes, he can do, but what we say here is that the trigger for him to pay is a sale or refinancing, and normally in shipping circles, when you refinance, it's a new lender, yeah. And the difference is this. Can I make this point? The difference is in refinancing and restructuring. When you restructure, you don't crystallize. There's no at that point. There's not a natural crystallization of a loss to the bank. There's been a restructuring, but you still own the money. Brandon still owns the money, and you still don't know what's going to happen. Refinancing, when you refinance with a new lender, it's equivalent in a sense to a sale, because you crystallize a loss. And that is why we have, maybe this is fairly or unfairly, conceded, or certainly perceived at this stage, that's why part 2 of clause 5 doesn't mention restructuring. It doesn't mean that the indemnity is lost on a restructuring. It just doesn't mention a restructuring, because at that point you haven't crystallized your loss like you do with a sale or refinance.
I mean, one of the curiosities about clause 5, picking that up, is that the indemnity doesn't cover losses or increased losses during a restructured loan, does it?
So
it makes express reference to a new loan in the next line after the first reference to refinance.
But the new loan surely is the new loan which is mentioned in recital G.
Yeah.
Yes.
Sorry.
So I mean, it talks about the outstanding indebtedness to HSH under the new loan.
Yes.
So that's the one that was taken out at the time. So, I mean, I understand the point about sale. If you sell, if the vessel is sold, then in a sense there's no continued you have crystallised the loss,
Crystallised loss.
both in relation to the outstanding indebtedness to the bank and losses made in the meantime. It's just crystallised.
Absolutely.
If you refinance, you say it's the equivalent to a sale if you read refinancing as meaning sale to a third party. Refinancing with a third party.
With a third party lender, yes.
Yeah, so in other words, you've got it effectively the same as a sale. It's a crystallising event.
Crystallising event. Because you've got to re-discharge the original, the new loan, the new loan.
But if you were to restructure, using your language of talking to HSH, and let's say they say, okay, we will extend the facility from 4 years to 8 years, but you have to pay Brandon has to pay an increased interest rate, and you premium. The terms are much more rigorous. The indemnity doesn't catch those increased terms, does it?
It probably does. Let me explain, because I will answer that and I will explain. Let me just tell you what happens. What happens is you get to 1st September 2015 and HSH, Brandon asks HSH for a restructuring to extend the loan up until 2018. It's agreed sort of like in principle. They exchange emails, but the bank will never sign up to the documents. They appoint Watson Farley Williams to produce the documentation, but it never goes anywhere. There's never anything for signing. And all the bank does is it confirms that it will not declare anybody in default. And then what happens is it takes about 3 years to get HSH to get their head round the fact that they're going to have to do this. The restructuring documents are signed on the 27th of December 2018, and almost at the end of that 4-year extra period. And then the restructuring documents allow them, it is 4 years, until I think it is 2019, September 2019, to do something. And it's at that point that Angelique can persuade the bank to take a massive haircut and to work the way through it. Now, that's what happened. If, in fact, taking the hypothetical, if on the 1st September 2015, the bank had agreed a restructuring, and say, for example, there was a facility fee or an increase in interest rate, both would be covered by the indemnity, because the facility fee would be just part of what you have to pay to the bank, and it would go to the overall net cost that you have to discharge. The overall cost that you'd have to pay to discharge the loan, and therefore you'd either get it that way, or Brandon would have to pay that facility fee or the increased interest rate separately. That will result, if that cannot be met out of ordinary costs of
operations. Sorry, I do hesitate just to interrupt you for a moment, because I think we're getting away from the question that I was trying to get towards, which I think you said you were going to answer. You raised the distinction between a refinancing and what you termed a restructuring. And what I put to you was that if you had a sale at fair market value to a third party, that would be a crystallising event. You could see easily what the losses to that date would be, both in terms of the sale value and operating losses in the meantime. I mean, what might be in this agreement called, in clause 5, shortfall and accumulated losses, and there's an indemnity in relation to those.
Yes.
If you refinance with a third party bank, i.e. the bank lends you a new amount of money on the back of the security of the vessel or whatever, you've got the equivalent, if you like, of a sale. Absolutely. You accepting that. And so at that stage, you would have, again, a crystallising event. You'd know what the outstanding indebtedness to HSH, which on this footing would be divorced from the vessel as well.
Correct.
And you'd know what the shortfall and accumulated losses would be.
Yes.
So the clause, you say, is triggered, it works. If you just kick the can down the road with HSH, you don't crystallise either a shortfall, you still have accumulated losses,
Correct.
but the agreement doesn't provide, at least on its face, for the continuing increased cost of the refinancing, of the restructured debt. Is what I'm putting, and I'm saying, do you get something from this, that the options open to Brandon and Nikolaos Frangou, putting aside the timing for a second, but just at the end of 4 years, if there's no sale to brother, are limited as far as the indemnity goes. If you want to trigger the indemnity, you have to do one of two things. You've got to sell, or you've got to refinance with a third party. That's when the indemnity kicks in, because it covers the shortfall and losses in those circumstances, but not others.
I understand the
So
point.
I hope I've made that sort of clear.
You have.
That's the question I'm going at.
And the answer is no, because I'll explain why. The indemnity is there, as you see mirrored in 3A, to make her whole. And what happens is you can't. The indemnity doesn't bite until the loss is crystallised, and you get it on sale, you get it on a refinancing. But if you just say, for example, restructure the HSH loan and kick the can down the road for 4 years, eventually, in 4 years' time, you're going to have to sell or refinance. There will always be a sale or refinancing at some stage. Always. Because it's a profit-earning chattel. It has a natural trading life. At some stage, you sell this vessel for scrap, you sell it to another owner who operates lower quality tonnage, older tonnage, or you refinance. At some stage, you will always get a sale or a refinancing. And that is why the loan was a 15-year loan profile. In 2015, there was still 11 years to go. My learned friend's argument is it couldn't have been an open-ended indemnity for the rest of that 11 years. Our submission to that is, yes, it is an open-ended indemnity until you get a sale or a refinancing. And if all you do is get a restructuring because you haven't crystallized the losses, and therefore there is nothing to bite on at that point in time. So
what might be put against you is that the new loan is said to be one which has a 4-year tenor, and what you can't do is to restructure with HSH for an indefinite period thereafter. If you want to trigger the indemnity, it has to be the outstanding indebtedness to HSH under the new loan. Now, it may be that, I know you say there's no halfway house here, but if we assume for a moment that there's no hair trigger, such that you had to sell or refinance on the 1st of September 2015. So assume there's no hair trigger, because you say that's just completely uncommercial. Let's assume that for the purpose of this discussion. But to trigger the indemnity, what you do need to do is to do one of two things. One is to sell to a third party at the best terms reasonably obtainable, or alternatively refinance with a new lender on the best possible available terms at the time of the refinancing.
Correct. And we say
what you can't, but
the sale.
The argument is what you can't do is just to restructure and kick the can indefinitely down the road.
Well, I agree that's my learned friend's construction, and we say it's wrong. We say there was a sale. The sale was in 2020. So after Angeliki had done her deal with the bank and got the haircut, she sold, and the bank consented to the sale. Now, that was a sale in 2020. We say that is a qualifying sale under the second part of Clause 5, because there is no requirement that she has to sell on the 1st of September 2015. That was the first premise my Lord Justice Snowden made. Assuming there's no hair trigger, the sale was in April 2020. Now, my learned friend says you've lost, that is not a qualifying sale. You've lost it because you didn't do it on the 1st of September 2015. And we say there's no time limit to the indemnity. Now, the reason why, essentially, the reason why the references are to sale or refinancing is because that's the only way you actually crystallize the loss for the purposes of the indemnity.
Or is it just the indemnity doesn't cover sort of said to be financial losses for more onerous terms of a refinancing, restructuring? It just covers accumulated operating losses from the vessel. The shortfall in accumulated losses, meaning operating losses from the operation and management of the vessel, but it doesn't cover as an indemnity any claims for more excessive interest payments or anything else in the meantime.
I hesitate to grasp at that because that would suit me. Because
well, I'm just trying to understand what the agreement means.
But I'm not convinced that that is what the agreement means. The reason being this. If there's no reason why the indemnity shouldn't respond to more onerous more onerous restructuring terms, say a higher interest rate. There's no reason why it shouldn't respond to that.
Well, the reason it shouldn't is because they didn't say it did.
Well,
the danger is...
Well, they do though. They do because all your restructuring you're doing is waiting a period of time until you sell or refinance. And therefore, what we say is the trigger is the sale or the refinance because you crystallize the loss. If during that period you have to, because if it is not commercially viable to sell or refinance on the 1st September 2015, which it wasn't, and if the best thing in everybody's interest was to kick the can down the road, even if that you had to pay more interest to do that, if that was the more sensible thing to do, then all that means is that when you get to the ultimate sale or refinancing in 2020, there may be either more money you have to pay back to HSH, and therefore a bigger shortfall, or there may be more accumulated losses because you've had to pay more interest. But what's triggered, what triggers the indemnity is the sale or the refinancing, and you look at the state of the shortfall or the accumulated losses at that time. I hope that makes sense and answers your question.
Okay, well, we'll perhaps come back to it. But you also have the point that whatever else refinancing means, it does appear to be a period of time during which this agreement will operate.
Yes. Going forwards, last sentence.
Yeah.
Correct. Because if you look at the last sentence, it is absolutely clear that if Angeliki takes on the vessel by refinancing it, makes more profit, she does a good deal. What happens, there's an interim solution on the 1st of September 2015 when there's an exchange of money, but that's just an interim solution. And then you do a final reckoning at the end of that refinancing, and if she's made a profit, she's got to pay back some money to her brother. So it is very much a one-way bet, this whole contract. And maybe the family scenario explains why.
All right, just before we move on, can I clarify one small point? I mean, I think you've been suggesting, if not positively submitting, that refinancing is pretty much a term of art in shipping circles as opposed to restructuring. But I mean, even supposing that to be right, there's no reason in principle as to why a refinancing cannot be with your original lender. And in fact, that's what happened here in 2011.
Correct.
Yeah. So
you are right that the new loan, the refinancing, was with the same lender.
It was the same lender. I mean, it was a very odd transaction for various reasons, but it was with the same lender.
You're right.
And if that is right, and unless there is some clearly understood learning in shipping circles, which I as a non-specialist in that area, I'm not aware of, I'm slightly puzzled as to quite where, or at least it would seem to me depend very much on the particular facts as to whether something is a refinancing or restructuring or something perhaps intermediate.
Yes. And I was going to make this point later when we get to the judge's analysis, but I'll make it now. The judge says, basically, his reading of this contract, he says, something has to happen on the 1st September 2015. You have to have this election. You have to elect to sell or refinance. It's an informal election. He doesn't even say it has to be communicated, but I assume it does. And then he says, if you get a later sale, or in this case it would be a sale, or refinancing, it would apply the same, that is somehow referable to that election that was taken on the 1st of September 2015, then that's fine, and then it's a qualifying sale or refinancing. But if you don't make your election on the 1st of September 2015 and kick the can down the road, there's no election made, and then you do a later sale or refinancing, then all bets are off and you've lost your indemnity. Now, for a whole host of reasons, that we say that is wrong. But one of the reasons we say is, well, it makes no sense, because it's vessel, and her clear evidence was at trial, and as the judge actually accepted, she was basically persuaded to do this by her father. She takes on this vessel. She doesn't have her own personal fleet. She gets to the 1st of September 2015. Yes, she'd like to sell or refinance. What more does she need to do in terms of this informal election? She'd like to sell and refinance. The point is, the state of the market at the time is it's just not commercially viable to do that. She does it at the earliest time it's commercially viable, which is but following the negotiations in 2019, she sells them in April 2020. Why isn't that sale in 2020 then referable to the position on the 1st of September 2015 and her decision to sell or refinance? It doesn't work. The judge's construction requires the mechanics of some sort of election to be very nuanced, because you have to mentally make a decision which and elect when you don't know you have to do that, because the clause doesn't tell you have to do that. But as long as you've done that, some later sale, it doesn't even have to be within a reasonable period of time, some later sale, as long as it's referable to that decision you made, becomes a qualifying sale. And we say for all those reasons, the mechanics just don't work, and it's an unnecessary gloss that's put on this on Clause 5. Clause 5 is simply saying, if you do not exercise your right to repurchase, Angeliki can now sell the vessel or refinance it. It goes back to the status quo, the default position, and when she does, you will reimburse her for these sums, provided it was either a fair market price or it was the best available terms at the time of the refinancing.
Why does the brother have to reimburse the sister?
Because
as opposed to the company which has actually sustained all the losses?
Because it reflects the commercial reality, which is the sister gave her personal guarantee in relation to Brandon. So the reality is it's the sister who...
So continued ownership of Brandon is the commercial reality against which we have to construe this?
No, because on the contrary, because she gave her personal guarantee, and the bank can call on that personal guarantee whether she owns the vessel, she owns the shares in Brandon, or whether somebody else owns the shares in Brandon. She's the one who's going to feel the loss. So that's why the indemnity is given to her in relation to the shortfall.
We're going to come on to this, but I did want to put the marker down at the moment that I certainly, for one, find it not straightforward that the indemnity is written to her as opposed to Brandon.
Yes, and the reason is twofold. She feels the loss. Well, it's the same answer. She feels the loss. But let's look at the two types of losses. In relation to the shortfall on the loan, she feels the loss because Brandon, if it sells, Brandon doesn't have a vessel anymore. Brandon is then an assetless company. The bank will look to her under her personal guarantee for the shortfall. And that is why the indemnity is to her. Now, when you look at the accumulated losses, this is where you need to understand perhaps a little bit more of the facts of this case, which is the bank required, or in 2011, my lords, the bank required the vessel to move not only from John's ownership, but from his management. So you have one company owns vessels and another company always manages them. It's the way it works in international shipping. And what happens is quite often the same person owns both. And what the bank required, and you see it in the documentation, and in particular the loan documentation, is that the bank required the management to move from John to Angeliki. And it's, I'm being reminded it's recycle K. Yes, it's recycle K of the agreement itself. So what happens is she manages the vessel through her company, MEM. And she manages, and this is part of the background to the 2017 NEH letter, she ends up having to manage 4 or 5 of John's other vessels because the lenders in respect to those vessels did the same and said they don't want to have business with John anymore. So she takes over all of the vessels and has to manage all of them. Now, because her company is managing the vessels, her company suffers the loss because if the income on Taurus 2 is not sufficient to pay back the bank its interest and its quarterly payments and pay the running costs of the vessel, if the income doesn't meet its expenditure, what happens is the vessel carries on trading, Brandon carries on paying back the bank, but Brandon becomes in debt to the management company. And it's Angeliki's management company, and that is why the indemnity is to her for the accumulated shortfall. Oh, now, you might say, why isn't it the management company? Mm-hmm. You might say, well, why didn't it say, in relation to the management company, John will reimburse the management company? And that's a fair point. Why doesn't it say that? It doesn't. It says Angeliki.
Well, it could just say Brandon. I mean, if Brandon is in debt to the management company, Brandon should just pay the management company what's owed, and then Brandon should be the requirement would be to indemnify Brandon for the shortfall and the accumulated losses which Brandon has suffered because it's paying the management.
You're right. In one sense, it could have done that, and maybe it would be cleaner. I think in this family context, it was simply being recognised that ultimately it is Angeliki who is going to be feeling the pain, feeling the losses, and therefore the indemnity was to the sister. Now, we've got ahead of ourselves, but essentially, we say Angeliki's claim is straightforward, very straightforward. We say the sale of the Taurus 2 in April and July 2020 was an exercise of the right to sell in Part 1 of Clause 5. The sale then took place, and that was a sale under Part 2 of Clause 5. And the proceeds of the sale were insufficient to cover the outstanding indebtedness to HSH and also the accumulated losses, operating losses. And therefore, John's payment obligation in Part 2 was triggered. And we say it is just simply an application of the express words of Clause 5.
So is it that you say that, for example, if what happened with HSH increased the indebtedness, i.e. that the terms of the new lending or the refinancing, restructuring, call it what you will, increased the indebtedness of Brandon to HSH, that is in fact picked up because it's just an increased shortfall.
Exactly. Yes, that's what I said earlier. It's exactly that. Yeah. And just to make good that point, your Lordship's interest rate point, if you end up having to pay a higher interest rate, all that means is the operating losses of the vessel will just be higher. Now,
well, no, that's not right. The operating losses of the vessel are one thing. It would be the operating losses of the company.
Of the company,
which would be higher.
You're absolutely right. That's much more correct language. It's the company.
Yeah. In other words, and you doing that saying that because it talks about losses from the operation and management of the vessel. That's what the agreement talks about. But what you're saying, I think, is that increased financing costs with HSH would be picked up by the indemnity because they would be, in effect, be reflected in an increased shortfall.
Increased shortfall because it costs a bulk carrier like this is going to cost $6,000-7,000 a day just to run the vessel, and if you got income coming in at only $8,000 a day from chartering her out, first you've got to pay back the bank interest and capital, and that probably will take you below your $6,000 a day for operating costs, and therefore the vessel will make a loss because you won't be able to pay all her suppliers, her crew and everybody else, because you don't make enough money from the income, and therefore the vessel will be running at a deficit and basically will borrow money from the managers.
So you aren't following what my Lord Justice Snowden has just said. You're putting it into the losses from operation and management category rather than the shortfall category.
Well, it depends what it is. So, for example, interest, I can see. If it's interest, I can
It's
see
shortfall.
it'll be shortfall. If it's in terms of an arrangement fee, a facility fee, something like that, that'll probably just get added to the debt to the bank, and therefore it might actually come out as the shortfall. If the bank requires a facility fee to be paid immediately, it might end up finding its way through into the accumulated operating losses because they've had to use the money to pay the facility fee.
I mean, in effect, what you're saying is that the expression shortfall and accumulated losses is really a collective expression to cover however it comes out, it's making your client whole.
Make my client whole. Correct.
In other words, if the vessel operates at an increased loss, its charter fees don't cover its outgoings to crew, etc. It's a greater operating loss of the vessel, which
Correct.
means it has less money to pay the bank, so that the bank's shortfall might increase. And if the bank, in addition, increases the interest rate on the refinanced facility, in a sense, that just further increases the shortfall. Whichever way it works, I mean, that mechanic.
That's right, and a good example of that.
But you say you crystallize whatever that amount is when the vessel is sold or refinanced
with a new loan, because you crystallize the figures because you can crystallize the shortfall to the bank because by definition you've got a new loan and you can crystallize the sum. I'll give you an example. During the first 4 years, her and this is in the accounts, which hopefully you won't need to look at, but during the first 4 years, she did not make enough money to pay the quarterly capital installments and the interest. Now, what happened was, during that 4-year tenor loan is, Angeliki made sure the bank was repaid. So although there wasn't enough money to do so and operate the vessel, they prioritized repaying the bank, and that resulted in an operating loss for the vessel for the first 4 years, which in the evidence was nearly $5 million by the end of the first 4 years. Because now, in one sense, you could say, I'm not going to prioritize paying the bank. I'll go in default. The bank will add it to the loan, and then I'll break even on operating the vessel. But then that will just increase the shortfall to the bank. So if you pay up the bank, if you pay the bank down, your operating losses go up, and vice versa. Now, just before we break for the short adjournment, I do want to just deal with one important point, which is the judge's construction of there having to be an election. And it arose this way. My learned friend ran a case at trial, which he's also running in his in the alternative before you today, which has stemmed from a very late pleading by him. If one turns to the supplementary bundle, one turns to his amended defence in tab 4. Sorry, it's the voluntary particulars. I do apologise. Tab 3. I apologise.
Tab 3, I've got re-amended defence.
So it's tab. Sorry, can I just? I'm taking myself out of course. Can I just get the correct reference? I do apologise. Got a wrong reference. I will. If I can just take.
I don't think it's in the index.
Ah, there we are. I was right. Sorry, it's tab 3. These are called voluntary particulars because the judge, my learned friend, tried to amend his defence on the eve of the trial. And he wasn't given permission for the amendments, but some of what he put in his proposed draft amended defence were treated as voluntary particulars, and that's why the document in the index is called voluntary particulars.
I'm slightly lost. I'm at, it's called voluntary further particulars I see in the index, but the document at divider 3 is re-amended defence.
Yes.
I'm in the right place, that's fine.
You're in the right place,
Okay.
and the reason it's called voluntary particulars is because he was refused permission to amend, but some parts of it were treated as voluntary particulars.
Fine.
And the one that he was allowed to run, because it was considered to be voluntary particulars, is the green in paragraph 32. And it's 32B. And it's 32B1. Upon a proper construction of clause 5 of the TT agreement, JF's clause 5 obligations responded only to a sale or refinancing completed, and it's the word completed by AF at the maturity of the Brandon loan. The sale of the vessel pursuant to Taurus 2 took place after that time and therefore does not engage clause 5. Now, the judge picked him up on that and said, do you really mean you have to complete the sale of the vessel on the 1st of September 2015? And if I can take the court to a part of the transcript, because the reason I'm doing this is it explains how the judge came to his election theory. If one looks at the transcript, if we go to tab 6 and look at the day 1, which is the essentially the opening submission, and if one looks at page 90 of the bundle, I'm taking it up at page 159 of the transcript, and Mr. Kaplan, my own friend, is speaking at the bottom of page 158 in his submission. And at the top of page 159 in line 6, he says, this part of the clause, this is clause 5, affords Mrs. Frangou a right to sell or refinance the TT at the end of the 4-year tenor if a clause 1 sale has not taken place before because of the clause 3 conditions not met. You can see this right is anchored to the point of maturity of the Brandon loan because the rationale behind the right to sell or refinance is spelled out as being in order to cover the then outstanding indebtedness to HSH under the new loan. The new loan being Brandon loan. So the meaning of these 5 lines, we say, is that if Captain Frangos cannot at the maturity of the Brandon loan buy back the TT under clause 1, Miss Frangou, free of any obligation to sell to him, can sell up or refinance to obtain cash to pay off what remains of the Brandon loan. During one 24-hour period. My lord, realistically, when someone apprehends that the expiry of a major instrument like the Brandon loan is approaching, arrangements are put in place the months leading up to ensure that at the date everything crystallises, a bit like buying a house in a chain. Deputy Judge, that sounds like a yes to my question. So people will make arrangements in advance because they know that if something is to occur, it has to occur within a 24-hour period. Yes. Deputy Judge, could you help me with the 24-hour period? What is the definition of it? Mr. Capley, my lord, it would be the final moment at which you either have to pay the balloon payment under the Brandon loan or be in default of it. Is this one of those midnight plus 1 minute situations? Mr. Kaplan goes on and says essentially yes. And then if you take on to page 161, the judge says, Mr. Kaplan says, line 5, I would say that the moment the Brandon loan expires, you would be in default. before the tenor expires, you've been in default of paying the balloon payment if you don't pay it. Because what is not anticipated here is that one party or other will simply pay the balloon payment to close out the loan. It is a 4-year period at the beginning that is the focus on everyone's mind. All right, dealing back from your construction argument, what is the day when the Brandon finance does expire or mature? Mr. Captain says the 1st of September. And the judge says, okay, if that fell on a Sunday, for example, would you be arguing it would be the Monday? And Mr. Kaplan then takes the de minimis point. So that was how it was in opening. Now, if one turns to tab 7 and one looks at page 117, the judge on day 2 indicates helpfully what he would like help with in closing submissions. And you'll see on page 185 of the transcript, the judge says at the end of the day, I'm reading at paragraph line 18, Mr. Kaplan will need to address me in due course, and no doubt you will, as to his case, as to what exactly that means, and whether it literally means what it says. But if Mr. Kaplan, if you are moving off the literal words of that clarifying paragraph, so in your draft re-amended defence 32B1, that's the one we've just looked at, I will need to see that in writing sooner rather than later. If you want to have another go at your voluntary particulars. So that is a temporal issue. That is the point that is said that you can only exercise, the option of sale could only be exercised at maturity. Right, that's the temporal stuff. So he put down the gauntlet to my learned friend. How does this clause work in practice? Now, if we then turn to the next tab and have a look at page 119, on day 3, he comes back to this, and I'm looking at paragraph 129, line 14, the deputy judge, then to come back to...
Wait. So just give me a second. Give me the reference again.
I do apologise. Tab 8, page 119. Line 14. So it's page 129 of the transcript. Then to come back to the point you were picking up in my premise, are you resting on your articulation of your case in 32B1? Mr. Captain, I wanted to raise that with you because by the phrase there, it is meant the end of the 4-year tenor, which I think people have been referring to sometimes the maturity of the Brandon loan in argument, and in submission and sometimes using the formulation end of the 4-year tenor of the maturity of the 4-year tenor. If there is any uncertainty about that, then that is what... No, I have approached this, and this is why I threw this out there yesterday, that the phrase at the end of the 4-year tenor in the first sentence of clause 5, as you see replicated elsewhere, is talking about the expiration or maturity of what we are calling the Brandon loan. So I'm treating that as the 1st September. I say my learned friend is not taking up your lordship's offer yesterday of re-amending. The judge says or re-clarifying his position. And then the judge says at 13, yes, I understand you to be running a case as clarified in 32B1 that the option has to be exercised and that a sale has to take place on that day because you are not relaxing that to within a reasonable period of time or anything like that. And Mr. Kaplan says no. And then if we turn to Mr. Kaplan's final submissions, which you'll see page 122 in the next tab, I'm picking it up on page 90, bottom of page 90, at line 24. The deputy judge says, your case about flexibility also represents a certain measure of forensic flexibility on your part, because I think you have moved off, or you are prepared to move off, the strict position that you insisted upon, that you insisted you would stay on a couple of days ago. I don't go down the route of reasonable time. I think it's de minimis. I think you said, you said in or around. Mr. Captain, subject to de minimis exception, but not reasonable periods going down that path. So you know, if you have arranged things 6 months in advance, but there was a last minute hiccup as you got towards the end of the 4-year tenor, I'm not saying if there was some sort of problem that led to it happening 2 days after the 4-year tenor ends, where HSH just turns a blind eye to the potential that it could hold you in default, you are suddenly to lose your right on it. And then the deputy judge says, and this is now perhaps the most important thing, he says, look, picking up line 20, or not having validly exercised it in time, and Angelica has a right. Can't she exercise that right by just saying, I exercise the right of sale? In other words, can she not elect on that day or in that legal moment, and having elected, she cannot go back on that because that is in the nature of an election, to say then she is then committed to sell and claim whatever she wants to when the sale goes through, or is she committed to, or she is committed to refinance and claim whenever. She can claim when she refinances, and if she doesn't elect on that day, she's out. Is that a construction? Because that's obviously, pausing there, the construction the judge actually adopts in his judgment. Mr. Kaplan, in my submission, something has to happen on the end of the 4-year tenor because you have suddenly got the balloon payment coming due. This 20 million figure is not going to go. The fact that HSH effectively rolled over the loan, in this case for 3 years, without putting Brandon in default and arresting the vessel and selling it is extremely unusual. Someone, I think, everyone accepts that. Something had to happen at the end of the 4 years. Either the vessel had to be sold to get money to pay the balloon payment, or a fee refinancing with another bank had to happen, whether where the cash was transferred to HSH and new debt taken out somewhere. You cannot have an exercise of this option after the 4-year period without some hinterland period where HSH is not enforcing the loan, because that's of course what happened on the facts of our case. Not putting Brandon in default. All of these things that actually happened, but it would be so unforeseeable to the parties that something like that would actually happen. And then over the page at 93 of the transcript, line 13, Mr. Kaplan, this is unforeseeable. You might expect some flexibility, a little bit here and there, but not that. The judge says, okay. So Mr. Kaplan says, it's really important to understand that something has to happen at the end of the 4 years. It cannot be nothing happens. There is no third omission. The fact that there was an unusual, unforeseeable third option in this case illustrates why this situation doesn't fall within the contract. So the point, the case being put to the judge is not just you had to decide to sell or refinance on the 1st September 2015, but you actually had to do it and complete on that day, and the money had to be used to repay the Brandon loan, the balloon payment. And anything else was out with clause 5. Now, there are obvious real problems with that construction, because the obvious one being under clause 1 and clause 5, John has until midnight on the 1st of September 2015 to exercise his option to repurchase. So how can you simultaneously have John potentially exercising his right to repurchase on the 1st of September, and Angeliki being able to sell the vessel and complete that sale and get the money in on the same day? And the judge realised that my learned friend's construction was wholly uncommercial and gave him the option of adopting the election strategy or construction, which the judge now adopts in his judgment. But my learned friend eschewed that and said no. Now, we're in this situation now where the judge has rightly not adopted my learned friend's construction in clause 5 because it doesn't work. But he's come up with his own construction that there needs to be an election on the 1st September 2015. And what he says, and if one goes to the judgment on this, is he says, I'm taking it up in the judgment to paragraph 68. I noticed the time, I'll just show you where it is in the judgment and then I'll stop. He says, 68, the first sentence of clause 5 confers a conditional option on AF as to the future fate of the vessel. That option involves an election to be made on the face of things on the date of maturity of the Brandon loan, i.e. the 1st September. It is expressed as a right to sell the vessel or refinance on certain conditions. that right is capable of being exercised by election being made on the relevant date. Such election is irrevocable by its nature. That's the essence of an election. And then he goes on at 69. If AF elected to sell, she need not by that date have concluded a sale contract for the vessel. Likewise, AF elected to refinance, she need not by that date have concluded the refinancing terms with the new lender. But the election between these options, and indeed between either of them and neither of them, needed to be made by that date on the face of things. It is, after all, just an election. It need not be. It need not even be written, he said. So, and he doesn't talk about it needing to be communicated. And then what he says later, and I won't take up any more time, he says, as long as you then get a sale that is referable somehow to that election, then you're okay. And after the short adjournment, I'll just deal with that election argument.
Thank you, Mr. Hill. I'm a little bit concerned. Perhaps you'll look to your timetable and how you're doing. Put it that way, because I think on the timetable at least, Mr. Kaplan begins at 3:30, and that's not far off.
I'm just to say on that, I had intended to give myself an hour in reply. I think I'll probably only leave myself half an hour in reply and use the other half an hour now.
Well, perhaps you'll agree that between you. Thank you very much. On the basis that we've run on 2:10.
Okay.
All rise, if able.